as well as Nyaya Samvadas, which has witnessed participation not only from India but even abroad. I am certain that this interactive session on judicial delays in administrative justice with such distinguished panelists is going to be another successful event. I would now request our beloved principal, Professor Dr. Mohan Bolla, to deliver the welcome address.
Sabha Saraswatyai Namaha. It is my humble and pious obligation to extend a warm welcome to this Vishwa Nyaya Samvada initiated by Kristu Jayanti College of Law under the aegis of Kristu Jayanti College and the CMI congregation managed by CMI fathers. And kudos to the great soul Saint Kuriakos alias Chara, the founding father of CMI congregation, whose Holy Spirits have been the guiding force behind the successful organization of the CMI and Kristu Jayanti institutions. My humble salutations are due to Justice, Goddess of Justice, Themis, and I extend a warm welcome to Honorable Justice Karunakaran sir. Sir is a manifestation of Karuna, and we are indeed very grateful to you, Honorable Sir, for acceding to our request to be the chief guest for this August function. And a very great subject sir has phrased out, and it is a burning issue ever, and the omnipresence of judicial delays is to be encountered by India, and the Indian judicial system shall recoup its vigor and vitality with the suggestions from Honorable Justice. And we are indeed grateful to you, sir, and I heartily welcome Honorable Justice Karunakaran, sir.
Thank you.
And now I heartily welcome our beloved Vice Chancellor, sir, Professor Dr. Ishwara Bhat, a constant researcher, a strong researcher indeed, and who has been contributing for the academic excellence of by heading this great university, the largest law university. And I take this opportunity to welcome Professor Dr. Ishwara Bhat sir. Ishwara Bhat sir, namaste and welcome to you. And now I would also like to welcome Professor Dr. Manoj Kumar Sinha sir, the director of the premier Indian Law Institute at Deemed University of Law, who has been kind enough to acceding to our request and join us in this virtual platform to encounter judicial delays in administration of justice. Hearty welcome to you, sir.
Thank you, sir. Thank you.
And now I welcome my good friend, Professor Dr. Srikrishna Deva sir, Honorable Vice Chancellor, National Law University, Odisha. Hearty welcome to you, sir. And thank you. And I take this opportunity to welcome our beloved, Reverend, most revered Father Joskuti PD, an institution builder, and has been a guiding support. And Reverend Father is the director of Kristu Jayanti College Autonomous now, and hearty welcome to you, Father. Now my kudos are extended to Reverend Dr. Augustine George, Principal, Kristu Jayanti College Autonomous and Founder Director, Kristu Jayanti College of Law. Hearty welcome to you, Father. And I welcome my own director, Professor Reverend Father Emmanuel PJ, Kristu Jayanti College of Law, to this great Vishwa Nyaya Samvada. Welcome to you, Father. And I also extend a warm welcome to our Father Lijopi Thomas, Financial Administrator, and Som Zacharias, Director, Knowledge Centers in Kristu Jayanti College. And I take this opportunity to welcome all the participants from all over India and abroad, eminent scholars and even judges and my good student friends to this great program, which would likely to enrich the legal fraternity with very great know-how, so that we can combat judicial delays in administration of justice, and expeditious disposal of cases also can be visualized with the recommendations from this great virtual platform, which is being organized by Kristu Jayanti College of Law. I thank each one of the participants once again, and I request Reverend Dr. Augustine George, Principal, Kristu Jayanti College of Law, to deliver a presidential address. Over to you, Father.
Honorable Justice Sri Karunakaran, Professor Ishwara Bhat, Vice Chancellor, Karnataka State Law University, Professor Srikrishna Deva and Director Professor Manoj Kumar, the resource people of the day, respected Father Joskuti, the Principal, respected Director Father Emmanuel, respected Principal of the Law College Mohan sir, distinguished faculty members, and all the participants. I join with the entire Kristu Jayanti family to welcome all of you once again to this Vishwa Nyaya Samvada. It is indeed a great honor to have such an eminent luminaries. We have the Hon'ble Justice Sri Karnataka. Indeed happy to know about him that he works with the power of intentionality and alignment with the higher purpose. The great people are known for their effort and effectiveness to manifest their vision by creating specific, achievable goals and initiating participative actions. Very happy to have the Honorable Justice to give the keynote address to the program. So welcoming sir once again from the Kristu Jayanti College itself. We have Professor Ishwara Bhat, our Vice Chancellor. I'm very happy to acknowledge the great support and guidance he is rendering to Kristu Jayanti Law College, and appreciate his effort to take the university to greater heights. He is a visionary leader who works into the future. He builds a new dawn. He works with imagination, insight, and boldness. Very happy to have him as a resource person for a session today. Our nation is blessed with the educational leaders who play a pivotal role in affecting the climate, attitude, the reputation of our country. They are the cornerstone on which our learning community function and grow. In this regard, we have two other eminent resource people today, Professor Srikrishna Deva, the Vice Chancellor of Deemed University, and Dr. Manoj Kumar Sinha. He's also the Director of the University of College, Deemed University of Law College. We place on record our gratitude to all of them. Kristu Jayanti College is an autonomous college As Professor Mohan Bolla explained, it is a manifestation of the dreams of Saint Kuriakose Elias Chavara, a social reformer and founder who lived in the 19th century, following his vision and the charism that we received from him. The CMI fathers entered into the education, and as of now, we have 59 colleges across the country and 700 plus schools. And we are into nurturing academic excellence, fostering values, and building a nation where we have the responsible citizen with their global competitiveness. At this moment, all of us hit with the pandemic. The education should not take a backseat. There are so many options available today, ranging with online tutoring, and the students are come to the virtual platform there. They can listen to the faculty members. Through all the effort of what we are trying to do, we are trying to become a normal. We are trying to become more and more relevant. And this is an effort from the College of Law to continue the passion to learn more and more and enrich the academic community. I really congratulate this College of Law for their effort for organizing such a program, and that is going to help and enlighten the academicians and the researcher community. The Kristu Jayanti College, together with the members of Kristu Jayanti College of Law, they appreciate the willingness and the dedication of all the members for their effort to keep the society moving. Wishing all of you all the best, and thanking all the luminaries and eminent the people who are the part of this program. I remain wishing you all the best. Thank you very much.
Thank you so much, Father, for your encouraging words. Before we proceed, I would again like to request all the participants to kindly switch off their video. Now I would like to call upon Professor Raksha Prakash to kindly read out the profile of Honorable Justice Karnakaran.
To one and all present here. This is Ms. Raksha, faculty member, Kristu Jayanti College of Law. Have been given a privileged task of introducing today's guest of honor, Honorable Justice Karunakaran, former Chief Justice, Republic of Seychelles. Honorable Justice was born on 5th October 1955. He obtained his LLB degree from University of Madras, Chennai. Sir holds a diploma in international law from Guildhall University, London, diploma in advanced leadership and management from International Law Enforcement Academy, Roswell, USA, and also a diploma in general jurisdiction from the National Judicial College, University of Nevada, USA. Sir has also completed certificate course in the areas like prevention of terrorism law, anti-money laundering, compliance and risk management program, etc., from some of the prestigious institutions. Justice Karunakaran has around 40 years of active practice of law in India as well as in the Republic of Seychelles. Sir began his practice as an advocate at the High Court of Judicature, Chennai, in the year 1981, and has also acted as the additional public prosecutor from the year 1981 to 83. He was admitted to the practice of law in Seychelles as the barrister and the attorney at law, Supreme Court, Republic of Seychelles in the year 1983. Sir has been a founding member of the Bar Association of Seychelles and also is a lifetime member of the prestigious Commonwealth Magistrates and Judges Association, London. Sir has been the legal advisor and counsel to a number of financial institutions, research companies, insurance companies, construction companies, and many other parastatal organizations and commercial enterprises in the Republic of Seychelles and overseas. From the year 1991 to 1999, Sir has acted in the various capacities such as the Senior Magistrate of the Republic of Seychelles, President of the Court Martial of Seychelles and the Tenants' Right Appellate Tribunal, President of the Juvenile Courts of Seychelles, Chairman of the Rent Control Board, and as the Chairman of the Seychelles Revenue Tribunal. Justice Karunakaran was elevated as the Judge of Supreme Court of Seychelles in the year 1999 and has served in this capacity for the period of 20 years and was retired from the Seychelles Judicial Service in March 2019. Sir has presented and published some of the research papers titled International Child Abduction in Commonwealth Context, Police Evidence in Court, Hague Convention, research paper on child protection in Seychelles, laws concerning alcohol and drug abuse in Seychelles, etc. He was honored by United States Department of State, Government of USA for the judicial service and has been a recipient of the highest civilian award, Bharatiya Pravasi Samman Award for the non-resident Indians conferred by the Government of India in the year 2015 for judicial service. With this, I present before you Honorable Justice Durai Karunakaran. Thank you all once again, and I remain.
Thank you.
Thank you, sir.
Thank you, ma'am. We welcome you again, sir. With this, we move on to our next panelist for the day, and I would call upon Professor Bhavya to kindly read out the profile of Professor Ishwara Bhat.
Very good morning to everyone. Professor Dr. P. Ishwara Bhat, Vice Chancellor of Karnataka State Law University, Hubballi, was born into an agricultural family. His early education was in Padalur and Kristu. He studied law in Udupi Law College. Sir was a gold medalist in LLM from Mysore University. Sir did his PhD from Mysore University and LLD from NLSU Bengaluru. Sir has over 40 years of teaching experience. He has taught in various reputed institutions. He was a Fulbright Nehru Visiting Fellow and involved in co-teaching NPO law in Columbus Law School, Catholic University of America. He has handled 5 research projects and guided 20 PhD candidates successfully. Sir has authored a number of books like Law and Social Transformation, Fundamental Rights and Administrative Liability, Idea and Methods of Legal Research, to name a few. Sir has published over 115 research articles and presented more than 100 papers in national and international level. Sir specializes in constitutional law, administrative law, legal research methodology, and intellectual property rights. It is an honor to have such a distinguished person with us today. Thank you, everyone.
Thank you so much, ma'am, for the introduction. Now, our next panelist for the day is Professor Manoj Kumar Singh. Now, I would call upon Professor Swati to kindly read out the profile of Professor Dr. Manoj
Good morning,
Kumar
one
Singh.
and all present here. It's my privilege to introduce Professor Dr. Manoj Kumar Sinha. He's a director of Indian Law Institute, a deemed university. He pursued his LLB from University of Delhi, LLM from University of Nottingham, doctorate from in international law from Jawaharlal Nehru University. His areas of specialization are human rights, constitutional law, international humanitarian and refugee law, international criminal law, international law and international institutions. He has published extensively in the field of international law, international relations, constitutional law, international human rights, humanitarian and refugee laws in reputed national and international journals. He is serving as a member of editorial boards of various reputed national and international journals. Sir was offered prestigious visiting professorship at Wellenberg Institute of Human Rights and Humanitarian Law, Sweden. He has also been elected as Secretary of All India Law Teachers Congress consecutively for 6 terms. He also served Indian Society of International Law as its director. He has been regularly delivering lectures at various institutes like Law College in India and abroad, UGC Academic Staff College, Training Program of ICRC, Ministry of External Affairs and Ministry of Environment and Forests. Apart from these, Professor Sinha has authorized numerous research articles, published and edited books, and has significantly contributed to legal literature. We welcome you, sir. Thank you.
Thank you so much, ma'am, for that generous introduction. Further, we move ahead to our last panelist of the day, Professor Dr. Srikrishna Deva Rao. Professor Rashmi, I would call upon you to kindly welcome our guest and kindly read out his profile.
Thank you, ma'am. Good morning. It is indeed an honor for me to introduce Professor Dr. Srikrishna Deva Rao. Professor Rao holds a master's degree in law from Kakatiya University, Warangal, Master of Philosophy in Law from National Law School, Bangalore, and PhD from Delhi University. Professor Dr. Srikrishna Deva Rao has actively involved with legal education and research in India at different national law schools and prominent universities across India, including Jawaharlal Nehru University and University of Delhi. He was a member of UGC Expert Committee in Law to transform legal education in India during 2010-12 time period. He was a Fulbright Scholar and a visiting fellow at School of Oriental and African Studies, London in 2013 and University of Washington in 2012. He has engaged with several research projects with UNDP, Law Commission of India, Ministry of Law and Justice, to name some. He was a consultant to Indian Medical Association, Swedish Development Corporation, Sir Dorabji Tata Trust, Child Rights and You, and Swedish National Science Foundation. His research interests include criminal law, human rights, legal education, and access to justice. Sir has pioneered in initiating clinical legal education courses in several universities. Sir was also the founding director of the School of Law at Indira Gandhi National Open University, New Delhi. Currently, he is the Vice Chancellor at National Law University, Odisha. Sir, we full-heartedly welcome you.
Thank you so much, Rashmi ma'am. Now I would hand over the session to Professor Mohan Bolla, and he would be conducting the panel discussion from here on. Professor Mohan, are you there?
Am I audible?
Okay. Yes, sir. Yes, sir. You are audible.
Once again, welcome Honorable Justice and Professors of Eminence, legal luminaries, and various participants from different universities all over India and abroad. We are here gathered to discuss about the judicial delays in administration of justice, and I will just have a prelude of about 5 minutes, and then Honorable Justice will deliver his address. And judicial delays in administration of justice nowadays they are omnipresent, and it takes us to make a note on justice delayed is justice denied, as ascertained by Gladstone. And we start the issue with an anecdote. An young lawyer, in the absence of his father, he would go to the court and help the court to render justice in a matter which has been there since long. And he acclaims and proudly says to his father, look here, I got justice rendered today in a case for which you have been struggling over years. And the father, senior lawyer, would say, you can't understand as to how to deal with cases, and he would murmur, naming maybe Asutha Mahataha Kunjara, but it was, if I were to promote speedier justice, I could never build a mansion house for you. This has been the attitude which has been well recognized, and there have been several leading decisions even, and the Supreme Court was very much worried. Even Imtiaz Ahmed case, we had a committee appointed under the supervision of the Supreme Court, and the highlights of the report analyzed by Dr. TCA Anant, the amicus curiae, were at that time itself they were very alarming. Out of the 10,000 odd cases that have been verified, what is the findings were such that as high as 9% of the cases have completed more than 20 years, and roughly 21% of the cases they took more than 10 years, and the average pendency is 7.4 years. And this kind of things have been alarmingly situated, and delay has been omnipresent in every court, and it has been omnipotent, and we are unable to encounter that to its logical end even today. And delay, as ascertained by the former Chief Justice, that delay and backlogs in the administration are of paramount concern. And the other former Chief Justice of India, R.M. Lodha, was suggesting that the courts shall function 365 days, but nobody was heeding to his suggestion, and it could not be materialized. And during his interview, very interesting remarks have been passed by Chief Justice, and just we'll take a watch.
नहीं देखिए, चीफ जस्टिस के नाते बहुत चिंता भी रहती थी कि लोगों को जल्दी न्याय नहीं मिल पा रहा है, हम वही पुरानी ढर्रे पे चल रहे हैं, रिफॉर्म्स पूरे नहीं हो रहे हैं, न्यायालय के पास एक्चुअली जल्दी निपटारे करने की कैपेसिटी, सबसे मतलब आज माहौल ये हो गया है, एज जज भी देखा, एज चीफ जस्टिस भी देखा, एडजर्नमेंट कल्चर है, माने कोई ऐसा मैटर नहीं होता है, निचली अदालत तो छोड़िए, जहाँ पे तो कोई भी ऐसा केस नहीं होता है जिसमें 20-25 एडजर्नमेंट के बगैर तय हुआ हो, कम से कम बता रहा हूँ मैं। हाई कोर्ट में भी लीजिए, करीबन 15-20 पेशी तो तारीख पे तारीख आपको मिली जाएगी। सुप्रीम कोर्ट कई मैटर्स इसमें हैं जिसमें डेट्स पड़ती रहती है, तो माइंड सेट जो एडजर्नमेंट का हो गया है और एक कैपेसिटी टू डिलीवर क्विक जस्टिस वो नहीं है, वो सोच के बहुत दुख होता है। आप देखिए कई तो ऐसे मैटर्स हैं जो 20-20 साल से बड़े हैं, लोगों को एक्चुअली मैंने क्षमता ही नहीं है लड़ने कि इतने साल तक में लड़ा जाए। दूसरा ये है महंगा भी बहुत है। देखिए सुप्रीम कोर्ट में तो जो हम सुनते थे अब ये तो नहीं कह सकते कि भाई पर्सनल जानकारी है, लेकिन एसएलपी में सीनियर एडवोकेट्स अपीयर होने के 5-5 लाख एक पेशी के 3 मिनट से 5 मिनट बहस करेंगे और 5 लाख ले जाएंगे। और उसके बाद देखिए अगर मैं तो ये भी सोच
So, sir, Honorable Justice was talking about the adjournment culture, and on the other hand, we had another Chief Justice who was even bursting into tears when he was sharing the platform with the Prime Minister very recently about the burden the judges have been facing.
The judicial system is so vitally connected with the development. And therefore, it is not only in the name of the litigant or litigant, people who are languishing in jails, but also in the name of development of this country, its progress, that I beseech you to rise to the occasion and realize that it is not enough to criticize. You cannot shift the entire burden to the judiciary. If you compare the performance of Indian judges with those in other countries, we are heads and shoulders above them. American Supreme Court decides 81 cases per year. The entire Supreme Court. 9 of them sit to dispose of just about 81 cases. Average disposal of an Indian judge is 2,600 cases, whether it is a Munsif or a Supreme Court judge. When judges come from abroad, and watch us working, they are amazed. They can't.
So the emotional urge and the request to the machinery for doing good to the situation we had witnessed. And in several cases, there has been the pendency of the matters almost 2 decades, and there has been a national mission for justice delivery system and established during the regime of the then Prime Minister Dr. Manoj Singh. And still we have matters pending, and the Supreme Court highlights the figures. In average, around 60,000 cases pendency is seen by us. And the delay, inordinate and unexplained, was paving the way for several even hardcore, erstwhile or decided to be hardcore criminals earlier by the same court, and having not been considered to be fit for living on this earth. They were even in a way inevitably the Supreme Court of India in Shatrughan Chauhan case was to commute the death sentences into life imprisonments. This is the background in which we are here, and now we need to discuss about the ways and means of combating the judicial delays to render good to the situation. Now I request and call upon Justice Doraikanu Kuriel, Honorable Justice, for former Chief Justice of Seychelles, to deliver his address for about half an hour, and then we will proceed further. Over to you, Dr. Karnakaran.
Thank you. Distinguished panelists, the principal of Kristu Jayanti College of Law, faculty members, academicians, my dear law students, participating ladies and gentlemen, Namaste, Subodayam, Vanakkam, all protocols observed. Greetings to you all from the Republic of Seychelles. I am very delighted to be invited to deliver a lecture on the subject, the judicial delays in administration of justice. I am most grateful for the honor, opportunity, and time you have given me to share some of my thoughts with you on this interesting theme. Please forgive me if I take the liberty of speaking my mind without reserve and at times being outspoken, perhaps overstepping my jurisdiction and expressing my personal views on many issues in this discourse. But all I do with utmost humility, respecting the views of others. At the outset, I must tell you that generally delay or procrastination of any action that we perform in our day-to-day life, for that matter, not only weakens the desired result of it, but also at times such delays defeat the very purpose for which we perform those actions. Obviously, judicial delay coupled with an alarming increase in the number of backlogged cases in our courts and in many other countries is now posing a constant threat to an effective and efficient administration of justice. Rule of law and good governance are put in peril. Above all, the very foundation of justice, namely public confidence in the existing justice delivery system and overall in the judiciary, is diminishing. After all, justice is rooted in public confidence. The issue of judicial delay and backlog of cases is not peculiar only to India. It is common among many other countries worldwide and has affected many jurisdictions. For instance, according to the Economic Survey of 2018-19, there are about 3.5 crore cases pending in the Indian judicial system, especially in district and subordinate courts. According to a recent survey, the Supreme Court of India has nearly 61,000 pending cases. The High Courts have more than 40 lakhs pending cases, of which nearly 94% have been pending for 5 to 15 years. The World Bank report of the same period also shows that the time taken to decide a case in Indian courts has remained static at 1,445 days. This issue raises a serious public concern. How are we going to cope with the ever-increasing backlog in our system and deliver timely justice to the ordinary man? Whereas the preamble of our Constitution has placed justice, social, economic, and political in the highest pedestal above all other features like liberty, equality, and fraternity. Needless to say, it is monotonous to say, justice delayed is justice denied. Indeed, delay is not a simple postponement of an action over a period of time, but in a judicial sense, it is an action in process that has irreversible long-term consequences. This process, with the progress of time, slowly, stealthily, and silently kills justice. The evolution of the right to speedy justice, its jurisprudence, and the line of its growth now as fundamental human right historically originates from the mother of all constitutions of the world, the famous Magna Carta of 1215, the doyen of English law of the 13th century. Section 40 of this great charter reads thus, which I quote, "To no one will we sell, to no one will we deny or delay right to justice," unquote. The last four words, namely, delay right to justice of the 13th century expression, born of political revolution, are historically very significant in the evolution of human rights. They are still relevant to the human rights situation of today. Therefore, delay in administration of justice is not a new social phenomenon. It is as old as Magna Carta and even much older, if I may say so. Theologically speaking, with the due respect to all religious faiths and gods, delay in justice is as old as Adam and Eve. Despite God in his power and wisdom had ordained that Adam and Eve shall die on the day they eat the forbidden fruit in the Garden of Eden, see Genesis chapter 3 verse 2. It took 930 years for his order to be executed. Even the execution of God's sentence of capital punishment was thus delayed for reasons only God knows. Hindu scriptures too show that the issue of delay in justice has been in existence ever since Vedic period. The ancient book Yajurveda stipulates under chapter 8 verse 50 that rulers should be committed to speedy justice and solutions of problems. From this exposure of its origin, let it not be thought that I am justifying judicial delays in the existing justice delivery system. I am not. Historically, the Sixth Amendment to the Constitution of the oldest democracy, the United States of America, also provides that, I quote, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public hearing," unquote. The right to hearing within a reasonable time is also recognized in the Universal Declaration of Human Rights of 1948. It is also guaranteed in the Charter of Fundamental Rights of the European Union, in the African Charter on Human Rights, in the Canadian Charter of Rights and Freedoms. The Constitution of the Republic of Seychelles also guarantees explicitly under Article 19(1) that right to a fair hearing within a reasonable time as fundamental right to every person. Thus, right to justice within a reasonable time is not only a fundamental right, but also a prerequisite of maintaining rule of law, good governance, and public confidence in the judicial system. Hence, right to justice within a reasonable time is now accepted as universal human right and so occupies the center stage of national and judicial goals of all civilized democracies in the world. All modern democratic constitutions of the world provides for the right to hearing within a reasonable time, and in some jurisdictions, it is also extended to civil litigations. Now, the repeated use of the phrase "within a reasonable time," which runs as a common golden thread throughout all those constitutional provisions, may puzzle a law student, particularly the term unreasonable, as this epithet appears to be vague, imprecise, and uncertain. One may reasonably ask, what does the term reasonableness mean in the context of setting a time frame in this respect? In determining the issue of reasonableness in the context of setting a time frame for the final disposal of a particular civil or criminal matter before it, the court has to make a subjective assessment of the entire facts and relevant circumstances peculiar to that particular case on hand, and in that light should consider whether the duration taken or likely to be taken from the time the case was filed in court until such time the judicial process ends to give final disposal to the matter is reasonable or not. In considering reasonableness, the duty of the decision maker is to take into account all relevant circumstances as they exist at the date of the hearing, that he must do in what I venture to call a broad common sense way, not as a judge sitting in the ivory tower, cutting off from the sensitivity of the community, but as a man of the world and come to his conclusion, giving such weight as he thinks right to the various factors in the situation. Some factors may have little or no weight. Others may be decisive, but it is quite wrong for him to exclude from his consideration matters which he ought to take into account. In this exercise, in my considered view, the court may also take judicial notice and cognizance of certain matters which are so notorious or clearly established or common knowledge, evaluating them as facts proved otherwise than by evidence. I hope this dictum would throw some light on the understanding of the term reasonable time vis-a-vis judicial delay. Having said that, it is interesting to note that the Constitution of India does not specifically provide for the right to a speedy trial or hearing within a reasonable time, either as fundamental right or otherwise. It apparently remains silent in this respect. This silence should not be seen as a lacuna or misinterpreted that Indian Constitution is outdated or stagnant or inadequate. It is not. The Constitution of India is an organic living institution. It evolves, grows progressively over time and adapts itself to new circumstances without being formally amended by the Parliament, but it does take place subtly and progressively over time and through pragmatic judicial interpretation, setting case law for future applications with effectivity. We have an active, strong, and progressive judiciary which from time to time swiftly and wisely interpret and gives force and life to the constitutional provisions and is paving the way to social justice, clearing of all obstructions. Thus, judicial activism is so vibrant and it fine-tunes and updates the Constitution effectively to meet the changing and challenging needs of time, society, providing the necessary growth to it and promoting justice, social, economic, and political as contemplated in the preamble. Indeed, in 1979, the Indian judiciary in its wisdom broke that apparent constitutional silence on the concept of speedy trial. It filled the gap through interpretation of the Constitution and adopted incorporating the international human rights norms on speedy trials to advance our constitutional growth with that of the others in the modern world. Accordingly, it made a dictum in constitutional law setting a precedent for the future. In the landmark case of Husainara Khatun versus Home Secretary, State of Bihar, AIR 1979, the Supreme Court held that the judicial procedure should be reasonable only when it ensures reasonable and quick trial. The court also categorically pronounced that expeditious trial is an integral and essential part of the fundamental rights to life and personal liberty enshrined in Article 21 of the Constitution. This remarkable dictum was destined to have important constitutional significance and consequence had to follow. Having said that, a court of law, be it superior or lower, appellate or trial in the judicial hierarchy, in my view, it should steer the law towards the administration and delivery of justice within a reasonable time rather than the leisurely mechanical administration or application of the letter of the law and procedures. Timeliness is absolutely necessary to the achievement of justice. In the process, undoubtedly, its primary function, amongst others, is obviously to adjudicate and give finality to the litigation. But in criminal matters, more importantly, justice must also be delivered within a reasonable time, not only in the interest of the accused, but also that of the victim, and above all, in the larger interest of the nation and its people. Sadly, at times, inordinate delays in the justice delivery system result in the criminalization of politics and politicization of criminality. It is truism that the criminal law is based on the fundamental principle that an accused person is presumed to be innocent till proven guilty. He is released on bail pending the final determination of the case. If the case is procrastinated in courts, for instance, 15 or more years, a criminal can remain free beyond the clutches of the court, sheltering under the different shades of politics, contest elections, and become a member of parliament or state legislative assembly, or even a minister at the center or in the state government, or at times even glitter as a star in the horizon of politics, because he has not been proven guilty yet. Thus, inordinate delays in the justice delivery system gives criminals who committed crimes enough freedom, time, favorable conditions, and opportunity to destroy or even to manipulate evidence, tamper witnesses, and records. Such delay also work as a double-edged weapon. It may also, in many cases, cause prejudice and works injustice to the accused person as well, who are facing serious charges. They may have the best defense evidence available to prove their innocence, but because of undue delay, they may not be able to prepare, proffer, and present their evidence in court at the time of trial due to many factors, such as the death of the key defense witness, fading or lapse or loss of human memories, loss or destruction of documents, etc. The delay itself destroys the authenticity of the evidence. With due respect, it is my humble view, the good sense of the court should always foresee the long-term ramifications of the judicial delays and adjudicate the cause so as to prevent or control the contingent delays that could possibly proliferate in future due to multiplicity of litigations on the same cause or matter. Needless to say, prevention of potential delays with judicial foreseeability is always better than cure. Therefore, our courts in India, like any other court of such foreseeability and sense would do elsewhere, should speed up trials and adjudicate the disputes accordingly and prevent chronic delays that has cancerously afflicted our justice delivery system. After all, the law is simply a means to an end, that is justice. If the means in a particular case fails to yield the desired result in time due to procrastination, repeated appeals, reviews, remittals, writs, abuse of process, frivolous and vexatious stays, retrials, unnecessary adjournments, which all, when drag on the cases for decades, the courts have to rethink, reinvent, reinterpret, and sharpen those means, the tools, in order to eradicate judicial delay, the enemy of justice, as Lord Lane once remarked. Hence, the courts should never hesitate when circumstances so dictate to adopt measures that are just and expedient to prevent the delays, procrastination, and the resultant public frustration in the due administration of justice. Now then, I would simply ask, which is to be preferred, the means or the end? I have to ventilate what a voiceless common man in the remote corner of the rural India feels and grumbles about the prevailing judicial delays when some courts, short-sighted by the letter of the law, prefer the means over the end and defeat justice. Faced with glaring injustice caused to a citizen due to procedural delays or legal technicalities in a particular case, we judges cannot adjust our spectacles on the nose and say, oh, there is nothing I can do about it. In this case, as agency X or department Y is responsible for this delay or that delay, or say folding our hands that the procedure code does not provide for this or that, my hands are tied, unquote. This approach implies that the courts have no power to do justice for that man over whose head the Damocles sword is hanging for nearly a decade or more. Justice cannot be postponed until the legislature finds it sweet time to make necessary amendments to the procedure code, or until such time that man becomes too old and to stand trial. What a task is set before judges. Clearly, someone has a duty to do something about this unjust situation. If the judiciary cannot, then who else can do something about it? In my humble view, therefore, the judiciary in this respect may adopt a triangular approach to expedite the trial or hearing of the case it deals with. First, the judiciary as an adjudicator, when dealing with such unduly long pending cases, should bear in mind that the paramount consideration in any adjudication is to serve not only justice, but more importantly, justice in good time. Secondly, the judiciary as a supervisor of overall proceedings of those cases before it should monitor and control the timely input, performance, cooperation, and coordination of each and every stakeholder involved in the process, and ensure a swift progress of the trial or hearing, defeating all and any delayed tactics applied by any in the process. And thirdly, judiciary as a protector of the rights of the citizens has to ensure that those rights enshrined in the glassy pages of the Constitution, statutes, and the international instruments, including right to hearing within a reasonable time, are properly respected, suitably applied, and effectively implemented by the authorities concerned, and protect the rights of those individuals at every stage of the proceedings and at all costs. Now, let us move on to backlog of cases, the culmination of judicial delay in administration of justice. The term backlog refers to a situation where there is a chronic accumulation of cases in numbers that far exceed the disposal capacity of the courts. As a result, the number of cases on the docket progressively increases and perpetually exceeds the disposal capacity of the court, which eventually contribute to inordinate delay of justice. When and where does delay begin? It is difficult to discern and ascertain when and where delay begins in the justice delivery system, or when the number of delayed cases become a backlog in a given jurisdiction and time frame. Unless a jurisdiction has set time standards as practice direction or protocols for the progress and disposal of a case, and set self-imposed accountability at every level within the judicial hierarchy, it is difficult to distinguish backlog from the normal progress of cases. In my considered view, different standards should be set at each level for the completion of civil and criminal cases. For instance, criminal cases, let us say 2 years. Civil cases, let us say 3 years. If a case remains undetermined after the set time limits, then it falls in the category of backlog. The focus should be given to the oldest in the backlog. Simultaneously, reasoning for the delay and accountability ought to be inquired into and ascertained for troubleshooting the system. Visioning exercise. It seems to me the major challenge the Indian judiciary is now facing is the delayed justice due to backlog of both civil and criminal matters at all levels, trial and appellate. In my humble view, using a visioning exercise, judiciary, after collecting all relevant data and doing necessary research, should formulate a strategic plan to eliminate, control, and prevent inordinate judicial delays in administration of justice and clear the backlog of cases, fine-tune and update the existing system so that it is time efficient and effective in order to meet the changing and challenging needs of time and public expectations by achieving a dynamic equilibrium between the inflow and outflow in terms of the volume of cases. Having read and observed the peculiar facts and circumstances surrounding the justice delivery system in India, to my mind, a backlog has occurred at all levels in the judiciary due to many factors. Some of the factors seem to have played and still playing primary roles, and others secondary, but all act in combination, perpetuating the delay, resulting in huge backlog. Although I haven't personally done any research based on observed facts and figures, on the face of the situation, it seems to me one can easily identify the factors, so also broadly suggest solutions wherever possible as follows. Number one, inadequate number of courts as well as judges, munsifs, magistrates or judicial officers at all levels in the judiciary has primarily contributed to the accumulation of workload and backlog. These numbers can be increased, and what one needs is political will and necessary budgetary allocation of funds. The recent enactment of the Supreme Court Number of Judges Amendment Bill 2019 that increased the number of judges in the Supreme Court from 31 to 34, including the Chief Justice of India, is a welcome move in the right direction. Outdated procedural rules, which are complex, long-winded, and time-consuming. Despite the procedure to secure our constitutional rights in the higher judiciary is efficient, effective, and easily accessible, the procedure for protecting the ordinary civil rights of a common man at lower level is not. Just as the pick and shovel is no longer suitable for the winning of coal, Lord Denning once mentioned, so also the procedural law of the 19th and 20th century is no longer suitable for the winning of freedom and timely justice to an ordinary citizen in the new age. Number three, understaffed and under-resourced judiciary and lack of proper infrastructure facilities such as courtrooms, offices, equipments, etc. This can also be remedied by the government, and necessary budgeting of the funds. Less budgetary allocation should be re-looked at. The budget allocated to the judiciary seems to be between 0.08 and 0.09% of the GDP. Number four, some redundant practices from bygone colonial eras ought to be reviewed and phased out. Older order changeth, yielding place to new. Inadequate case management and case flow management can be improved by giving necessary training and refresher course to judicial officers from time to time using experts in the field. 6. Delay in modernization to embrace technology or failure in widely adopting ICT, information and communications technology system in court administration, case management, maintenance of records and documentation, etc. The problem of business like attitude from some members of the bar and small size of the legal professionals or lack of advocates in certain suburbs or rural jurisdictions have to be looked into. Lack of professional ethics, the discipline by lawyers on overcommitments, double booking of cases at the same time in different courts, and the delayed tactics applied for repeated adjournments should be discouraged. Civil and political vibrancy at times, social unrest in the country has also given rise to increasing number of litigations. The leaders of political, social, religious groups should also be taught on peaceful ways of ventilating their grievances in public, not to resort to unconventional and sometimes violent ways to show it, disregarding the rights of their fellow citizens. Growing litigation culture among public and lawyers who go to court as a first option should be discouraged. 11. To meet the need of increasing economic and financial activities due to foreign direct investments, international trade and commerce, special tribunals may be established to deal with the disputes in this area that would considerably lessen the workload of the law courts. On the remedial side, one may also suggest, for instance, new protocols may be agreed upon by judges on delay reduction measures and time standards for disposal. Number of court working days may be increased. The longer period of court vacation may be relooked at. The court may follow, setting priority to old cases for hearing and disposal purposes. Court-heard cases may be heard first before starting newer ones, setting a ceiling on the number of court-heard cases before starting new hearings. For instance, pre-hearings may be held to screen out unnecessary trials, saving the precious time of the court. Plea bargain can be encouraged. Having said that, in my humble view, morale and enthusiasm amongst the judges at all levels has to be uplifted by providing adequate remuneration and favorable conditions of employment. Adequate administrative support may also be provided to the judges and magistrates. Separate commercial courts may be set up to handle commercial and small cost matters in all rural districts. Simultaneously, alternative dispute resolution mechanism may be resorted to and extended to all jurisdictions and put into optimum use. ADR settlements would substantially reduce the backlog and diminish the delay in justice delivery system. Again, mediation and conciliation should be encouraged and facilitated to reduce the workload and clear the backlog. Many more such problems and possible solutions are still left untouched. I hope the law schools in India will be able to identify and provide solutions to those problems through research and innovative measures to diminish judicial delays and clear the backlog of cases in the state as well as national levels. In conclusion, I would like to state that the future of the judiciary of India much depends on the younger generation of the legal professionals. In spite of the myriad problems in the justice delivery system and implementation of the necessary reform, I am very optimistic that the increasing number of intelligent, well-educated, well-trained, and technologically well-versed students who are coming out of many renowned law schools in India each year can do it. Many of them rise through the judicial system, which is independent and strong. They are well shaped to occupy the position of judges in the higher judiciary in future. Youths of great Bharat dare to dream a judiciary which evolves and shines as a center of judicial excellence and a role model in the region, delivering justice for all in a timely manner, inspiring public confidence, protecting, preserving, and defending the Constitution, and securing the rights of the individuals. Excellence is not an act, but a habit. Aristotle. Thank you very much for your kind indulgence. Jai Hind.
A very enlightening and comprehensive presentation, very well articulated, Honorable Sir, right from Vedic period down the line with very great and acute suggestions for combating delays in the justice. We could hear, and the triangular approach and the viewpoint focus must be on the common man in the rural and remote areas, and the suggestions that the decentralization of the judicial system in rendering justice by establishing courts. But we have, in reality, we do not have for every district and every state sufficient number of courts. And the political will, as Honorable Sir has rightly pointed out, is the issue which is lacking in. And let us hope that the future Modis and other rulers would take these issues into consideration and do good to the situation. Very kind of you, Honorable Sir. And now I call upon humbly Professor Dr. Ishwara Bhat, who has been very eloquently defining the role of law schools as to prepare students with technically sound and with all judicial capabilities to come out to render justice. I humbly request Honorable Honorable Ishwara Bhat Sir to deliver his address for about 15 to 20 minutes.
Thank you very much, Professor Mohan.
Kindly stay back, sir.
I'll be.
Kind of. Now, Professor Ishwara Bhat Sir.
Yes, yes. Am I audible?
Yes, sir. Sir is
Am I audible?
Yes, sir. Sir is audible, but not visible.
Yes. Okay. Now, right.
Yes, sir. Now a little more adjustment is required. His face is not fully visible. A little more adjustment to the system. Yeah. A bit more. Closer.
Oh.
Yes, sir. Yes, sir. We could see, sir. A very good morning and warm welcome once again.
Very good morning to all. Respected panelists, especially which is Karunakaran, Seychelles, Professor Kumar, Professor Srikrishna, for Justin George, for Joseph Kuti, and for Emmanuel, Bolla, for Kristu Law College. First, let me congratulate the Law College for organizing
Respected Ishwara Bhat Sir, your voice is breaking. Your voice is breaking.
There can be some adjustment possible. Speaker.
Okay. Is it okay now?
No, sir. The voice is completely breaking.
Yes, still it is a blurred voice.
Sir, can you just reconnect the audio?
It's completely muted out. Sir, the voice is not audible at all. Yeah.
Hello.
Respected sir, we are not able to hear you. Maybe if you turn off the camera the video camera, probably it will work better.
Uh-huh. Shall I start?
Yes. Yes.
Am I audible?
Yes.
Now
yes,
you are audible.
yes. It's clear.
Okay. Now it's clear. Okay, thank you. First of all, let me congratulate Kristu Jayanti Law College for organizing this webinar. Of course, the college is doing quite well in terms of various programs, infrastructure facilities, faculties, library, and various facilities. The person for discussion.
Voice is sir.
Sir, your voice.
Something that
Sir, your voice started breaking again.
Because
Sir, voice is breaking again. I think some technical support is required.
Hello.
It's breaking, sir. It's not audible, sir. It's not audible. It's not audible, sir. Yes, sir. That is a better option.
Hello.
Yes, sir. Now it's clear.
Now, okay. Thank you.
Yes, sir.
The topic that is chosen is of great significance because justice is the first virtue of every civilization, as John Rawls points out. Justice, social, economic, and political. These are the fundamental things that to be attained through the Constitution. The constitutional scheme is for ensuring that all the people will attain justice, social, economic, and political. And administration of justice is something that promotes the cause of social, economic, and political justice. Because without administration of justice in accordance with the law, it is not possible to ultimately promote the cause of justice, social, economic, and political. Although economic justice and social justice and even political justice can be attained through various means outside the courts of law. Still, when it comes to conflict resolution, ultimately it is the legal method of administration of justice that counts. That's why it attains a lot of significance. Article 39A of the Constitution, it is specifically provides that the operation of a legal system shall promote the cause of justice. Thus, linking the whole legal system with justice is something that is explicitly done under the Constitution. Although the constitutional text does not speak about speedy justice as one of the fundamental rights, it is implicit in the very idea that procedure established by law shall come to the respect of right to life and personal liberty. Thus, if the procedure established by law has to promote the cause of justice, protect the life and liberty, it is essential that speedy disposal of cases is a must In case speedy disposal of cases does not take place, it will have some greatest impact on a whole sum of society. Other components of the process of law will be adversely affected. Specific inclusion of speedy cases, council, and various other components of the process were suggested confidentially. Suggestions that procedure research law will take up all the the judiciary that it is an integral component of fair procedure of law.
The voice is still not clear, sir.
Not clear again. I don't know what to. Hello.
Yes, sir. Voice is not clear.
Sorry.
It sounds like there is a network issue.
Yes,
so can you kindly check with the technician to see whether internet is...
Yes, I have a technician right with me.
Yes, sir.
But there is some problem. He is not able to make adjustments.
Now it's okay. With that tone, if sir continues.
Okay. See, if there is an inordinate, inexplicable, and unexcusable delay in an administration of justice, then it goes to the very root of the right to life and personal liberty. Most of the cases which are pending before a court of law, it is criminal cases which are double the number of civil cases. I mean, criminal. Still, there is another proposition, another idea pointed out by one of the chief justices. Thinking about this 3 crores probably the not right because most of the cases are having a duration less than 1 year. See, once the Supreme Court under trials for jails are afraid of their right to personal liberty and right to life, and this is going against the Constitution. They consider speedy disposal of cases one of the requirements under the Constitution, and releasing all the under trials from the in case the duration which they continue to languish is more than the maximum period of punishment, and releasing them is one method of ensuring of speedy justice. Of course, in a subsequent case, in 2000, there was an approach which is exceeding half the duration of detention. Releasing them from jail is the appropriate method of protecting the rights of individuals. It is how the court interpreted that. We come across a number of judgments relating to speedy cases, especially in relation to death cases. We have some significant can revolt is the bench, which have about question of say, reducing the punishment from hello, hello, okay. Okay, due to technical problems, I am not able to use that. Then I come to we'll go for the next year. That will be appropriate. Okay. Yes. It's essential that there ought to be concerted effort from the set of judiciary administration and all the participants in judicial process that there's advocates or other persons so that there can be effective administration of justice so that before the cases will be done in a timely manner. Technical difficulties will not be continuing. I am thankful for the question given and I wish all the best to the webinar. Thank you very much.
Due to technical errors, sir will be joining again, and we'll go to the next speaker now. And kindly bear with us for the technical problems. Now, I request respected Professor Srikrishna Deva Rao sir to take over the session about the understanding and best practices to avoid judicial delays. Professor Krishna Deva Rao sir.
Thank you.
Yeah.
Thank you, Professor Mohan Rao. Justice
very kind of
Karunakaran.
See after a long time.
Okay, thank you. Yeah. Justice Karunakaran, Professor Ishwara Bhat, Professor Manoj Sinha, Professor Mohan Rao, and friends. Let me take another 15 to 20 minutes to interact with you on 4 important issues which are relevant. Justice Karunakaran has comprehensively explained the causative factors and what are the solutions which are required. And as a judge and who is well acquainted with the Indian situation, has painted a larger picture. Let me look at 4 issues today, next 15 to 20 minutes. First issue, I would like to take for some time about how do we understand a judicial delay as a student of dispute resolution, student of constitutional law, criminal law, who is concerned of coming out of the obstacles which are barriers to the justice. That's the first issue. How do we understand the judicial delay? In this context, I wanted to take you through very interesting study of Global Survey on Insights into Access to Justice 2019. Second, I will look at Professor Mohan Rao mentioned about Imtiyaz Ahmed case 2012. Imtiyaz Ahmed was a state of Uttar Pradesh, and the Supreme Court of India in this case has requested the Law Commission of India, which has come out with another very interesting study on 245th report of the Law Commission of India. That's my third issue. Fourth issue is the study which we have conducted in the state of Odisha. The Department of Higher Education, Government of Odisha has requested us to look at 17,000 pending cases, disputes in the higher education, and suggest how do we deal with this. This we have submitted a report. So that's my next issue. Last issue is how do we strengthen community dispute resolution. So these are the things I try to cover within a minimal time. Justice Karunakaran already has said it's difficult to define judicial delay. In common language, judicial delay means postpone and put off. And in the court environment, it means cases will not move as fast as we think about it. Professor Ishwara Bhat has explained about how the speedy trial is an integral part of the Indian Constitution, particularly Article 21. In the criminal law, several cases we have, Indian Supreme Court has clearly mentioned this. This is the one. And in the, when we look at, this had an impact. In fact, I have taught a course in the alternative dispute resolution. That's where my personal view is all the stakeholders in the justice delivery system combinedly, cumulatively responsible for this phenomenon, be it a lawyer, litigant, government legal counsel, judges, including the administrative organizations, the several criminal justice system, civil justice system, you name anything, including the law, procedure, rules, complex, outmoded laws. Every one of us are responsible for institutionalizing this backlog pendency areas. And the pendency and delay is denial of access to justice, and which is vital for the rule of law and largely responsible for eroding the confidence of the people. It causes hardship to victims and their families, and its ability to deliver justice in a timely fashion. In essence, delay frustrates justice. It may not cause so much of inconvenience, hardship to somebody who is illiterate, who is available in the city, law firm, prestigious lawyers, those who are privileged lawyers, but it causes enormous hardship to the litigant who comes from a distant place and several others, whether remote corners of the India. I would like to look at, there are 4 immediate obvious barriers to justice. What are the 3? The first is external factors. The external factors which are the important barriers to access to justice is such as monetary, those who cannot pay, cultural barriers, geographical barriers which exclude or fence out certain sections of society by preventing them access to courts. Geographical barriers or distances from courts can cause great difficulty to litigants, accused, witnesses, if they have to undertake day-long trips to reach to the courts, and when they come, the matter is adjourned. Second factor is internal factors. First is, I spoke about external factors. Second, internal factors are such as delays, complex procedures, technicalities, which affect everyone in the system, but disproportionately impact those with fewer resources, what Justice Krishna here calls little Indians. This raises the question of whether every individual who approaches the legal system or is made to participate in it as a defendant in a civil suit or an accused in the criminal trial, can they expect an expeditious hearing and a fair outcome? The third factor is quality factors, which are caused by uncertain and inconsistent application of law and arbitrary procedures which affect substantive judgment and outcome of the case on merits. The quality of human resources are also important. The orientation and training of lawyers is also important. Judges is also important, and all those who are involved in justice delivery. So these are the 3 factors I thought I'll just flag it out. And since 1990 in India, lawyers, judges, legal academics, those who are involved and concerned about the justice delivery system have been trying to minimize or to learn to minimize the case management and court management and trying to search for alternatives to dispute resolution. I will not go into again defining what is court delay. It is, as I said, it is related to procedure, way of working of the court, absolutely there is a no communication or a least communication between the court and the litigant. I'll come to that. That's one of the important finding of our study in the higher education disputes in the state of Odisha. So how do we develop a better interaction between the court, advocates, litigant, and there are several complex situations which are responsible, factors responsible for delay. Let me come to the Global Insight Study on Access to Justice 2019. This is a survey based in 101 countries, which underscores the barriers and hardships for people trying to solve everyday legal problems. It's the first effort to capture comparable data on legal needs and access to civil justice on a worldwide scale. The key findings I wanted to just share with you. The first finding, justice problems are everywhere and frequent. The survey says approximately 49% of the people surveyed experience at least one legal problem in the last 2 years. Second important finding is justice problems negatively impact people's lives. 43% of those surveyed reported that their legal problem adversely impacted their lives. They said more than 29% reported that they experienced physical or stress-related ill health as a result of their legal problems, and more than 23% reported that they lost their job or had to relocate. Third important finding, which is very important for me, is the most people do not turn to lawyers and courts. That's what Justice Karunakaran was mentioning about that. Less than third, 29% of the people who experience a legal problem sought advice from the family members or friends to help them better understand or resolve their problems. Even fewer among them, 17%, took their problems to an authority or third party to mediate or adjudicate their problem, with most preferring to negotiate directly with the other party. So these are the three important significant results of the Global Insights into Access to Justice survey of 101 countries in 2019. Let me come to the third issue, is Imtiaz Ahmad case. In fact, I was involved, helped the Law Commission of India at that time when this matter was referred to the Law Commission of India. So what is this case? Very interesting, Imtiaz Ahmad case, where the Supreme Court has taken up this matter, where there was a lot of pendency of the criminal cases, particularly under the Article 226 and under the Criminal Procedure Code, the court can issue stay the proceedings. This was the stay was granted by the high courts under Article 226 of the Constitution and our Section 482 and 397 of the CRPC. And they found 77% of pendency in 4 high courts. Because what are the stages? Major proportion of pendency is at the Calcutta High Court, 32%, followed by Allahabad High Court, 29%, Patna High Court, 9%, Orissa, 8%. All this taken together, the pendency of the cases in the High Court by issuing of the stay. Stay is granted by the High Court when these cases are pending, and 79% comes from only 4 High Courts. What are the stages of this pendency? At the stage of registration of FIR, High Court issues stay and it's pending. Similarly, investigation was stayed, framing of charges were stayed, and this under the exercise of the powers of the Article 226. So then the Supreme Court has referred to the Law Commission of India, and the Law Commission of India has submitted very interesting again a report of the 245th report on arrears, delay and pendency. This is the 245th report of the Law Commission of India, arrears and backlog, creating additional judicial man and women power. This is the 2014. First time the Law Commission of India attempted to define what is delay, what is area, what is backlog. They have defined delay, they have defined pendency, they have defined areas, they have defined backlog. And they attempted to develop a rational, scientific definition of areas and delay. And also they have come out with the rate of disposal method. And also it suggested about, naturally, the suggestion from the Supreme Court after the Imtiaz Ahmad case is how many judges we require. What is the method of calculation of requirement of the judges? So how many more courts are required, more judges are required. It suggested strategies for the case strategy, court management strategy, infrastructure, mandatory time limit, and also looked at some of the issue was about how do we fix up at least the delay causes sometimes in at the time of the writing of the judgment, announcement of the judgment, how much time should be there? Is it 1 week or upper limit of 1 month? How do we eliminate? Another issue which was also discussed about is elimination of writing long and elaborate judgments. How do we use technology? I think that was the time e-court system started in the Supreme Court, national court management system started, national areas judicial grid started. I think these are some of the issues which were discussed in the 245th report of the Law Commission of India. Let me come to the third issue. Third issue is related to the judicial delays in the higher education disputes in the state of Odisha. This is a research project we have undertaken and which was referred by the government of Odisha. We studied around 17,000 disputes related to higher education that are pending in various forums such as State Education Tribunal, Odisha Administrative Tribunal, and the Odisha High Court. We studied and analyzed the nature of disputes and suggested litigation management policy to resolve them. First, we classified the disputes into two broad categories. First, disputes related to management and administration related to higher education disputes that include grant in aid, recruitment promotion, financial disputes, minor criminal offenses. The second major disputes are related to disputes based on students and parents' complaints, complaint against university rules, complaint against management and administration. In this, one of the important significant finding of this study, we found that one of the major reasons for the delay is absence of prompt communication between the government department and the advocates representing them. Absolutely, there is no channel of communication between the higher education to the lawyer and to the litigant. So that was the major one. It was also found that most of the time, government advocates requested for adjournment. What is the reason? The reason is awaiting instructions from the government. In fact, there was a study conducted long ago in Scotland, which studied the culture of adjournment in 4 criminal courts. and they found that the 3 criminal codes where there was a liberal adjournment and the 4th criminal code was very strict. The judge never ever used to give any adjournment. If an adjournment is asked, whether the prosecutor or the government advocate, any lawyer, whoever he may be, he was grilled in such a way that the next time the lawyer will never ask for adjournment. So that the major where they found that the 4th criminal code, they never give an adjournment. That was the reason. They have created a culture of not giving adjournment. That was a facilitating factor. And later on, they realized that all the 3 other criminal codes also started following this. So this adjournment is a major reason for the delay we have seen in several of the reports. So we also found in our higher education disputes in the state of Odisha, adjournment is just, they will say, awaiting instructions from the government. So we have also suggested, if you look at 2010-11, the Ministry of Law and Justice attempted to create a litigation management strategy at the national level and at the state level. Of course, we have not taken seriously, neither the judiciary nor the academics and the lawyers. We have to come together and evolve a specific methods of how to deal with the litigation management. But this is very important. The litigation management has to come from all of us, and including a specific disputes. So by utilizing the litigation management side of the government of officials, the government advocates, and some others, and we have also involved the several think tanks in India, those who are involved in the judicial policy research in India, we have suggested to the government of Odisha that you create a special litigation management system. And we said, if you allow, majority of these disputes can be resolved. We can have a tribunal, voluntary tribunal sitting in the university, taking a proactive stance, calling both the parties, and we will settle. If you require, we will have a retired judicial officer, we will have a retired IAS officer, retired academician, 3 of them come together. So this is what we need to think about, innovative, creative methods of a litigation management, methods for dispute resolution. I think that we have submitted our report, and with this experience now we wanted to look at all over India, how do we resolve? It is simple, except the major disputes, everything can be resolved. Let me come to the last point where some of us who teach alternate dispute resolution, we tend to call the ADR as an appropriate dispute resolution. Because we need to evolve what is an appropriate dispute resolution. Of course, it's an alternative. So appropriate dispute resolution is necessary. All of us, we have seen when the Anglo-Saxon legal system has emerged in India, when the East India Company, the presidency towns, when they started coming up, they have completely implanted the Anglo-Saxon legal system on the indigenous legal system which is existing, of course, which has defects, which may not be professional, it may be caste-ridden, other defects will be there, but instead of strengthening the dispute resolution mechanism, they have absolutely killed that. Earlier times, the dispute, only selected disputes used to come before the court. So there is no filtering mechanism at the village level, taluk level, any other level. Therefore, unless we go to the root cause and you think about appropriate dispute resolution methods, this problem will haunt us. It will haunt much more after the lockdown or unlock or whatever the situation. We are going to face enormous burden, and that impacts on the GDP, economy, and several other issues. So therefore, appropriate dispute resolution method is very important. For many people, ending dispute is an important outcome. There's an old proverb in all languages in India. The person who succeeds, wins the case, also cries in the court. And the person who loses the case also cries in the court. Nobody, no win-win situation. Everybody has lost. because of the enormous delay, impact on the economy, impact on the livelihood, impact on the life, several other, nobody is happy. So therefore, for many people, ending a dispute is as important as the outcome. Thus, being able to bring a matter to a sensible conclusion without the time, stress, management costs, opportunity costs, reputational risk, loss of morale, entailed in long drawn conflict is a major thing all of us we have to think about how do we avoid or how do we develop appropriate dispute resolution method. The vast majority of the matters can be dealt by mediation. Justice Karunakaran has already pointed out, mediation, several disputes can be resolved quickly and effectively. The Consumer Protection Act 2019 has for the first time added a chapter on mediation, made mandatory mediation. In fact, I'm happy to inform we have taken the lead. We have requested the state consumer consumer department, government of Odisha, now give us a mediation center in the university. In fact, some of these, like a juvenile court, should be in the university. Consumer dispute mediation center should be in the university. Unless we help, unless we sensitize the students to coming into the litigation, mediation is not only a professional skill, but also personal skills. I'll tell all my colleagues, we have to evolve a method of alternative dispute resolution. Absolutely, conflict will lead to a responsible life. Therefore, we all have to adopt the appropriate dispute resolution or alternate dispute resolution, not only in our personal life, but also professional life. And it is an important academic skill the law students have to learn. It's also cost effective. There's no need to calculate the time which was lost, litigation process. As I said, it adversely impacts on the GDP of the countries. And the 2019 Consumer Protection Act has clearly said the mediation at the stage of admission of complaint or at any later stage, if acceptable to both the parties. The Consumer Protection Act 2019 also underscored that the mediation cell will be set up in each district, state, national commission, and its regional benches for quick resolution. See the section 74 to 81 of the Consumer Protection Act 2019 states that matters to be referred to the mediation cell. So these are the 5 issues I thought I'll share with you. I'll end with my optimist always. I used to say, we have now, all of us, we have to think about how do we strengthen the community dispute resolution. We have created Nyaya Panchayat, we have created Gram Nyayalayas. Even when the National Law School of India University has set up in the Ramnagaram Rural Mediation Center, that was a successful experiment long ago. Before the Family Courts Act or any other act thought about a mediation, we said we have a responsibility. We have a responsibility to call both the parties and settle. Later on, the Legal Service Authorities Act, Lok Adalat Act now has legitimized some of these. So at the personal level, at the professional level, we should think about this strengthening the community dispute resolution. Personally, I believe community dispute resolution is the third wave of access to justice to settle cases outside the court. Look at the global insights into the access to justice survey. Majority of 30%, they said they wanted to settle outside the court. We should evolve the mechanism. We should train the village panchayat. We should train the religious leaders. Look at whether we agree or disagree, the long pending Babri Masjid dispute, Supreme Court has taken a lead. So we need to think about how we can evolve, search for alternatives to courts, court procedures, and advocate shifting the focus to the community dispute resolution. And I'll end with this. I think I have taken much time, and thank you for giving me this opportunity to share some of my views and random thoughts. Thank you.
Very kind of you, sir. Very great insights of the research you have conducted, and the suggested alternatives take home must be from your enlightening speech that there ought to be decentralization of the justice system and litigation management into various segregated units of civil, criminal, consumer, family, etc. That is being done, and further decentralization is required depending upon the stage, and the community dispute resolution mechanism and appropriate dispute resolution mechanisms also have been the matters of highlight to combat the delay, and utilizing the services of the retired professors and judges is also an interesting area, and Justice Frankfurters and such other people as that of the American judicial system. There ought to be such utility, but we need to have such platforms whereby there can be very good and better suggestions. And now may I request Professor Manoj Kumar Sinha sir to take over the session and talk about the remedial measures to combat judicial delays. Manoj Kumar sir.
Thank you very much. Yes. Thank you very much, Professor Mohan Gopal.
Yes, sir. Very kind.
Honorable Justice, former CDI of Republic of Seychelles, Honorable Vice Chancellor Professor Ishwara Bhat, Vice Chancellor of Karnataka Law University, Honorable Vice Chancellor Professor Srikrishna Deva, Vice Chancellor of National Law School, Odisha, and all friends and students. It's a great challenge for me for two reasons. The first, things have been covered, and I was so impressed and highly benefited by the talk of all previous speakers, and particularly by the Justice Karunakaran. He dealt in this subject in a very second manner and covered all the aspects related with the speedy trial and pendency related issues. As we know that, and I don't need to re-emphasize, but I would like to start with, speedy trial is a part of right to life and liberty guaranteed under Article 21 of the Indian Constitution. Therefore, delay in disposal of cases may in a way result in denial of this fundamental right. I will just summarize, and I start with two important points, which emphasized by Honorable Justice Karunakaran, and in his speech, he referred about the international instruments as well. In the international instruments, he has mentioned about the European Convention on Human Rights, International Covenant on Civil and Political Rights. The point which I would like to highlight, that all human rights instruments have a provisions related with the speedy trial. There's no doubt about that. But one specific instrument which I would like to point out here in my speech, that is the International Covenant on Civil and Political Rights, which he has also mentioned. Under that, it recognizes that International Covenant on Civil and Political Rights, it recognizes domestic system. It gives the primacy to the national judicial system. And if any complaint reaches to the monitoring body, that is Human Rights Committee, it without fail, it asks the complainant or author of the complainant to exhaust local remedies. So exhaustion of local remedies or domestic remedies is very fundamental in almost all human rights instruments. So they gave emphasis on the how the Human Rights Committee has viewed such kind of situation where judicial system is unduly prolonged. The Human Rights Committee has discretion. Human Rights Committee has discretion to waive the conditions emphasizes on exhaustion of all available domestic remedies. If the judicial remedies which is available at the national level, if it takes more than 5 years, so in many cases, Human Rights Committee has waived that particular condition. So we see that we have got an answer that reasonable period we can consider. So like what Professor Deva Rao has also mentioned, that report also identifies the areas and pending. We have to identify. So if cases which are like filed immediately within 1 year, that cannot be added in the case of pending 1 year, 2 years or something. So sometime it will require, it cannot be hushed up. Any matter, it requires to decide adjudication of any case by the honorable courts. It takes some reasonable time, what Honorable Justice has also mentioned. So reasonable time may be between 1 to 4 years and 5 years. So beyond 5 years, the cases can be considered in the list of the pending cases. We should notice. So docket explosion is very important. Like people have a faith on the judicial system and they go into the court to resolve their disputes. So they have a faith on the judicial system. So we have to make a distinction. It's not the today a case has been added and then you say, no, Supreme Court has 60,000, 70,000 or something. So we have to see the cases which are pending for the longer period, means after 5 years and beyond. If any system you take, whether it's a national system or international system, you will find generally it takes 3 to 4 years or 5 years to decide a matter. So some reasonable time has to be given, which has been emphasized. So now Human Rights Committee, which I have highlighted, which have answered that unduly prolonged means beyond 5 years, that is there. The another important case which is related with the delay and which also again mentioned by the Honorable Justice Karunakaran sir about the Shatrughan Chauhan case. In the Shatrughan Chauhan case, a large number of the accused who are on the death row phenomena have been there, because delay was unnecessary, for without any justifiable reasons, delay was there. So Shatrughan Chauhan case pondered over 5 important points. Out of the 5 important points, that is the first is the delay, then second, insanity, solitary confinement, judgment declared per incuriam, and procedural lapses. Also procedural lapses. For our purpose, procedural lapses and delay is very important. So these are this case has thrown light and number of accused who were under the death row phenomena, death row that has been commuted to the life imprisonment under the by the Supreme Court after. The third point which I have, so when we talk about the pending of the cases, we have to look where cases are pending. So we have, as in the morning, Professor Mohan has already given a very nice presentation about the pending, and there he mentioned that till I think the very latest information in the Supreme Court around 60,000 cases are pending. In the high courts, if taking note of all the high courts in India, around 48 lakhs cases are pending. So when we talk, we say we have more than 3 crores pending in the India. So more than 3 crores cases are pending in India. So we think about the everywhere pending is huge. Like Supreme Court is reasonably it's not very bad condition which can be managed and which they are also honorable judges are managing, trying to see that speedy disposal of the cases high court. But the real concern we have in the subordinate courts, the focus we have to look into the subordinate courts. The delay in a huge, it's around 2.75 2 crore and 75 lakh cases and maybe more. The old data I have on 2018 and 2019. So we have around 3 crore cases pending in the subordinate courts in India. That is the area we all have to focus. What we have heard from the learned speakers, they said, how that we can involve the law students also to make them aware, and they can play very important role in improving the judicial system when they pass out from the law school. That can be a very good idea. But the real challenge in the rural areas which we have seen, why this is there? There are a lot of factors are there. The first is the the very bad conditions. Lot of judicial, in district level courts are in a very bad condition, lack of infrastructure. And then another, before I'll come to the lack of infrastructure, the another important point that overall in subordinate, the sanction strain in the lower judiciary around 22 to 23,000 judges, and there are huge vacancy, around 16,000 at present are occupied. There are 6 to 7,000 vacancies are available in the subordinate courts. And I'm very happy to say that there was a push given by the Supreme Court of India, and in fact all honorable judges, and particularly Justice Ranjan Gogoi time, he has given special attention to recruitment in the lower judiciary. A large number of a deadline was given to the various high courts to conduct the interview and complete the recruitment process within the 1 year. So that is the sanction is still, and we have 19 judges out of per million people. So we number of judges. So judges are also overburdened. Judges are also overburdened compared to the developed nations. What we see, we don't have sufficient number of judges to dispose of that particular matter. There, speaker or earlier speaker, if we start taking note of the speedy trial or pendency of the cases, what we'll achieve? We'll achieve two important things. The first, a large number of under trials in the criminal matters, particularly large numbers of under trials, around 70% are languishing and jail. We have 60 to 70% under trial prisoners and the jail. And out of that, there are if they are, so their presumption of innocence, they have a right to life. They have also other freedoms. So they can if their cases are taken on a very urgent basis, because some of the cases bail pending trial has not begun, and in many cases they have already crossed, had they punished the period, they have already crossed as under trial prisoners. So if courts take note of that, there are a lot of judgments where there is a execution problem on that particular part. The another, which civil procedure section 89 talks about the ADR, alternative dispute resolution, and that is taking place, and what Professor Rao has also mentioned, Lok Adalat and other things, court sitting and trying to see how to segregate the cases. So segregation of the cases are equally important when we decide about this matter. The other 3 points which I have in my mind, which which can improve the judicial, which will help in the reducing the pendency from the lower courts and also in the higher courts and high courts, Supreme Court and the other. The first, which I feel timely disposal of cases, which Supreme Court has to play a very important role in the timely disposal of the cases. A time framework has to be decided, and as we discussed, Supreme Court has also looked into this particular matter and maybe a necessary direction. So if executive whatever step take, but if the Supreme Court of India takes various serious and they have been taking, if a timely disposal of the cases after the admission of a case in the Supreme Court. There's a second important point which I feel personally, a mechanism to monitor progress of cases from filing to disposal, till disposal. So we have to have a mechanism to monitor progress of cases from filing to till disposal, and then we can also do the priority cases, grouping of cases. That is also very important. Another important, we have to address shortage of judges is also very important aspect which needs to be taken by the executive, and of course I'm sure that in days to come things will important. Next point which I have, modernization, computerization and technology, which takes me back to the point which I highlighted in the subordinate courts. The conditions of the subordinate courts, even officially, in very dilapidated conditions. Number of courts are in very bad conditions, not sufficient number of staff. There is no northeastern states conditions are very pathetic, and even in the in the northern India you find lot of places the not necessary infrastructure is not there. If you want to monitor the cases from the filing to disposal by the central body, it's possible because now e-courts is done. There's national judicial grid system has come in the place. E-courts are there. So, but these courts have to be provided with the infrastructure where internet is fast, modern computer is there, electricity is addressed, in power backup system should be there because power failure is continuous there, even in big city. If that is very big, then you are able to monitor effectively. So many times you try to connect and you find it's very difficult, and that problem we face even in big cities. It's not only confined to rural areas. Next point, which I feel, maximum use of the alternative dispute resolutions, and particularly mediation, pre-litigation mediation, negotiation, lok adalats, and other things we can apply. Most important point, where is a very important, that is the framing strict guidelines for grant of adjournments by the, especially at the trial stage. Strict guidelines we have to create for the grant of adjournments, especially at the trial stage. It's very difficult for the judges, sometimes they will not seek adjournment. They will come out and say ki senior is not in good health or something, so next day. So some serious thought has to be given. Though there are 3 adjournments, the judge can take note of that, and judge can play a very important role in that particular. Exploding of functioning on the weekends, Saturday, Sunday, special courts to reduce dependency. That is the very important. If these are the points which I have highlighted are taken serious note, and I'm sure that the points which I have said is not a new, but previous speakers also spoken about, but use of technology, monitoring mechanism, maintaining a detailed record from the filing, strict guidelines for the adjournment. If these things are mentioned, taken care of, I'm sure that things will improve in disposing of the cases. And this is as we started with, and I have said already, I don't want to go much because everything has been said, everything has been spoken already by the previous speaker. So I thought these are the important points which we need to be. So our focus area for the delay in judiciary, we have to start looking into the subordinate courts. We should not pinpoint High Court and Supreme Court. That is taken care by the Supreme Court and High Court's Honorable Chief Justice. I'm perfectly and they are working on that. But subordinate court concern has to be addressed, where the role of the High Courts become very important, and any efficient direction, any proper direction from the particularly Supreme Court of India, time to time they have been issuing, I'm sure things will improve. So we all have some responsibility. We all have an obligations. And for that matter, as you all see, and Tarijit Pasayat always mentioned that 90% litigants, for the 90% litigants, their Supreme Court is a district court. They don't go beyond. They don't have resources. They don't have a legal representation. They don't have anything. Even in criminal matters, so whatever decision is rendered by the district court or subordinate courts, that become final. So large number of poor sections of the society, underprivileged sections of the society, weaker sections of the society, women, scheduled castes, scheduled tribes, disabled persons living in the rural areas, their Supreme Court is the district court. Matter ends there. It never comes to the High Court or Supreme Court. And that is also one of the reasons the cases are not very high. So our focus, so bottom-up approach, we have to think about the bottom-up. Whatever the limited role, whatever the role we can play, we all have to work. And I'm sure that initiative taken by the Kristu Jayanti College of Law, inviting on Justice Karunakaran, Professor Ishwara Bhat and Srikrishna Deva, And I hope that this exercise will continue and the points shared by the eminent speakers so taken care of and things will improve. So I want to once again, I thank the organizer and particularly the organizer of the Kristu Jayanti College of Law and Professor Mohan for inviting me to sharing my views on this particular topic. Thank you very much.
Thank you very much, sir. The highlights of sir's speech is further again still focusing on the crores of cases pending. There ought to be the down the line approach to establish perhaps gram nyayalayas and the other alternative modes of settlement of disputes and the strict guidelines with respect to adjournments, and it's indeed an issue, and monitoring systems, as far as monitoring systems are concerned, many high courts have district in charge as one of the judges have been appointed, and they have been monitoring, and to a certain extent government, the judicial system has taken cognizance of dependency and trying to improve the situation. But a lot more is expected to be done to ensure that there won't be much pendency. And the stages where there can be pendency is that having some guidelines that have been given and circulars issued by various high courts to the magistrates and judges. What has been observed is that the SR number has been given and case number is not being given. Even years are passing, months are passing, and the courts, the wisdom of the judges is such that if they give the number, it would add to dependency and trying to avoid that kind of thing, and avoidance of litigation is also observed. And very rightly pointed out about the HR committees and the human rights committees and strengthening of the human rights commissions and committees. That is also a very good measure as suggested by sir, and we are very much delighted to hear to Manoj Kumar sir's enlightening speech. And now we'll go for question and answer session, and I did not see any questions that have been put in the chat boxes, and I think Harish sir may raise a question so that we'll take up the question and answer session now to any one of the speakers, and including justice. Yeah. Political pressure. There is a question, sir. Political pressure is the reason for slowing the justice system. And are there any other pressure from government, governing party in judicial system? This is the common question that is raised, and I request Honorable Justice to answer this. Political pressure and involvement in the judicial system, justice system. If that can be if that is the reason, how to combat that?
Yes, sir. I believe there is no political pressure that can contribute for the delay.
Yes.
That I am clear.
Okay.
Because judges are independent.
Yes.
And their integrity, we trust their integrity. I believe the political pressure from external, use will not have any influence on the judges. So that cannot be related to the delay in justice.
Sharma got the answer from sir, and if there is any supplementary question, that can be raised. Yeah. Anyway, Harish sir, do you have a point to raise? Kindly unmute yourself. Unmute yourself.
Okay.
Can you unmute
Basically,
yourself and speak?
Yeah. You
Yes.
able to hear me?
Yes, sir. Yes, sir. Yes.
Yeah. Respected distinguished guests, okay, Honorable Justice Karnakaran, then Vice Chancellor of the Law University, and Vice Chancellor of Odisha University, Krishna Rao is not there. Here on the screen is not visible. He's a very good friend of mine. We both were there at NLS when he was doing MPhil in 1990 in National Law School when it was in Central College. I was doing LLM then.
Okay.
So, I know him personally well. Last time I met him was in probably Krishna Rao.
Yes.
This is Harish here. Me and Animesh Upadhyay were classmates in law school when we were in Central College, and you remember that you came along with me to Vidhan Sabha for your custodial deaths project thing when my mother was in Vidhan Sabha at that point of time. Last time I met you was in the era of 2016. Yeah. Okay, it's nice to see you now. And Professor Manoj, nice to know you, sir. It was good. You raised the issue on the under trials, which was there in my mind too, because a lot of people under trials have even exceeded their term of punishment. Had they been punished, they are still languishing in jails. The preamble of the Constitution starts with such a pedestal which is placed on which the justice and judicial system is placed, that among the 4 cardinal principles, it starts with justice, then liberty, then equality, then fraternity. Okay, with such a pedestal of justice being placed in the preamble, we are yet to see justice at all levels happen in this country to the common man. And this is the very famous saying, "Justice delayed is justice denied," was given by Gladstone, William Gladstone, the former Prime Minister of United Kingdom. He was the man who gave this quotation, "Justice delayed is justice denied." Justice hurried is justice buried. Also, the other side of it is there also. In my view, practically speaking, even the judicial data, which Mr. Manoj said, 3.5 crore pending cases, is in the judiciary only. It's talking about district courts, high courts, and Supreme Court. I can share you a real-time data of only taluk level, which is a real-time data available on the website. Right? I will probably show you that one. I'll share the screen in with that with the data which is on the National Judicial Data Grid. Okay, I'm not able to share. I think you must allow me to share the screen.
We can, sir. We can.
I don't know why the share screen is not happening. Yeah. I'm trying to share the screen, but it's not happening. Okay.
Highlight the points, sir.
Okay. You can visit that one, National Judicial Data Grid. And it shows the current data of the pending cases in the country. Okay. It shows district-wise, taluk-wise, everything. Okay. Going by population, we were supposed to have judges based on per million population, which we don't have. We have only 16,000 and odd judges in the entire country. Okay, we have for every 20 lakh, you have an MP in this country, but you don't have judges on that rate. You need at least 60,000 judges, and you need a 24/7 court system judiciary to work. Okay, and you need the judiciary is overstressed, understaffed, and you have at lower level incompetent and judicial officers. Very sorry to say that, with due respects to all people in the judiciary, there is a lot of delay caused due to incompetence, due to unreasonable adjournments being granted both from judicial officers side and also from the advocate side. And the government is the biggest litigant in this country. With government being the biggest litigation, if you ask any government advocate, you see they will not appear in courts regularly because their old bills are still pending. Okay, they do not go to court. They are unable, and sometimes they will not even be able to know what is happening at the departmental level. They don't get the information on time also from the department, because it goes to a legal department. from the concerned section in that particular department. Suppose you say the municipal corporation, the law officer will have some details, but he has to get details from JDDTP, Joint Director Town Planning, from Revenue Officer, from a lot of other departments. That doesn't happen. That communication gap which was being mentioned also by Professor Ishwara Bhat, I think so, in the beginning. And that communication is a major lacuna in this thing. You need to have recently when this election was happening, I had an interaction with Mr. Chidambaram when he was in Bangalore. I suggested that you should have Supreme Court benches in all the zone wise, central, south zone, east zone, west zone, north zone, because a lot of people, the common man doesn't have affordable justice system in this country. There is no affordability of healthcare, public healthcare. There is no affordability of justice system. People are unable to go to Supreme Court because it's a costly affair, luxury of time, luxury of money. Both are not available at their disposal. So you should make justice being delivered to their doorstep. So it should be approachable. It should be at their own zonal level, at least, that you have one in Hyderabad or in Madras, the Supreme Court bench, then one in eastern part, one in the western part, one in central part, northern part. Already it is there in Delhi, because these litigation, these pending cases are only of the judicial system. Somebody mentioned about the tribunals. I think Krishna Rao was talking about tribunals. I think so. Lot of things are pending before tribunals. Variety of tribunals: central government industrial tribunal, state government industrial tribunal, income tax appellate tribunal, Karnataka administrative tribunal, Karnataka appellate tribunal. So many variety of tribunals are there. Those are not taken into account in these pending list of cases at all. I think Mr. Manoj will agree with me on this, because they are only talking about the major judiciary which is showing pending litigations. How do you handle these things also? Because they are all like a quasi-judicial body. Consumer Forum, Consumer Fora is part of the Consumer Affairs Ministry, Food and Civil Supplies Ministry in the states, and Consumer Affairs Ministry in the center. And I was there in the consumer movement when Jaji Mandana took it over in Karnataka in '86. It took 5 years for Consumer Forum to be set up in Karnataka. In '91, the first Consumer Forum came into existence. So see, this is such a infrastructure gap is there. When the act is made, there is no infrastructure to put the machinery in place. Yes, even now the 2019 Act is yet to come into effect. Date has to be still fixed. The 2019 Consumer Protection Act, which we are talking about. So you need to have an effective administration system which will take care of real-time data to see that there is justice being delivered, and it should be visible also on the ground. You need to have more judges.
Yes, sir. Harish sir, are you interested to raise any point specific to enable?
Not much more. Everybody is on the same page according to me. But you need to have a 24/7. You can have a 24/7.
That's a good suggestion. And you're to move efforts through the parliamentary affairs.
No, I am also doing that. I have suggested this in the manifestos to be. It is being brought into the manifesto also for having zonal-wise Supreme Court thing in some of the parties' manifesto.
That's well and appreciated issue, sir. And there is another question suggestion that at police station level there ought to be monitoring of the cases if possible. And
correct.
Can the panelists
coming to police station? I give you an example, sir. On police station in Bangalore, you have 109 police station. Okay, you have totally 20,000 cops for 1.25 crore people.
Yes.
Okay, they are overstaffed, understaffed. Even in the Corona crisis, they have never been able to go home for 15 days. Some of the police people. The police department is the worst department. The police personnel never get any benefits because they have no right to go on strike. All other employees in this country go on strike through their associations and get their salary increased. Police department is the most neglected. You go to the police department, quarters of the police personnel, you will see seepage in the wall. You will see
don't
broken
mistake
toilets.
me, sir. What is suggested is that police station level are the jurisdiction at the decentralization of the issues, taking a police station into consideration at the jurisdiction of the police station, and the minute level of segregating the cases to be monitored. A system is to be developed in such a way that a police station is taken as a center point for the jurisdictional purposes and not more than that.
I know, even jurisdiction, there are sometimes cases where two police stations say this doesn't come on my jurisdiction.
Yeah.
Lot of cases, when you go to file, they will say this doesn't come under my jurisdiction. You go to the neighboring police station. There is lot of cases when people have gone to media to even register an FIR.
Okay.
I can quote umpteen number of cases across the country on this matter.
So there is another question, sir. Is interpretation of laws contribute for the delay?
That's the advocate's job to interpret it also in such a manner that to convince.
Let the panelists be given a chance to answer.
Oh, sorry. I thought it was for me. I thought it was speaking to me on that. I apologize.
No. I'm not. My intention is not that. The panelists are requested.
No. I thought it was put to me. That's why.
Honorable Justice, interpretation of laws while interpreting the law, or for interpreting the law, can there be contribution for delay?
Yes, of course. The interpretation should be purposive interpretation. We must account the delay while you give interpretation to any phrase, whatever occurs in any procedure code. Always we must be purposive and see it whether it the interpretation, there could be several interpretation, but the interpretation which is able to expedite the trial, expedite the proceeding should be accepted. So it has a role, of course.
Very good. Thank you, sir. Actually, there has been a situation where the Supreme Court has found out I think Justice K.T. Thomas, he was highlighting the fact that after completion of the trial and reserving for the judgment, there has been an inordinate delay, and that has been highlighted in a sensational case. I think I can show. Yes, this is Anil Rai versus State of Bihar. After the case has come come to the stage of delivering the judgment, and especially it appears that there is the interpretation and other issues taking those issues into consideration. There has been inordinate delay, and to avoid that, the Supreme Court has come down with some guidelines. However, as rightly appreciated by Justice Karnakaran sir, there ought to have been avoidance of such inordinate delay at that stage. Thank you. And is there any other question found out by Preeti Joseph? Is there any other question found out? Any more questions?
Justice wants to say something, I think. Justice Karnakaran wants to speak.
Yes.
Yes, when we talk of the delay in delivering the judgment, from the time the case has already been completed, the hearing and everything is complete, but the judges take their time to deliver judgment. That's what I refer to in my discourse. Unless a jurisdiction has set time standards as practice direction or protocols, not only for the progress and disposal of the cases, at the same time, there should be some kind of self-imposed accountability at every stage, every level in the judiciary. The superior courts at least ask them why you have exceeded the protocol. For instance, if the case is completed, the judgment should be delivered at least in 2 months' time. There could be some reasons in some cases where the judges may not be able to deliver judgment. If that is the case, then there should be some kind of report that should be submitted to the higher courts, and thereby you can put some kind of self-imposed accountability. They should give at least a reason why it is delayed, the judgment is delayed. So this kind of protocols should be observed, and it should be formulated by the higher courts, giving direction to the district judges, magistrates, and they should be accountable to the superior courts, I believe.
I think two points when it comes to the delay due to the judgment announcement of the judge, pronouncement of the judgment. One is quality judgment is also important, and of course the judges during their orientation, they have been trained how to write in a precise, sharp language, and as far as possible limited pages. The major problem, even in the 245th Law Commission has observed, is how do we cultivate this habit of writing a short judgment? This is the one. Second is there need to be some protocols, as Justice Karunakaran has mentioned. We need to have a minimum for a small cases, maybe a week, maybe a month. There are cases, if you look at some judges, including the Supreme Court, people very much quote about Justice Krishna here. In one of the important judgment, he sat day and night, 7 days he has given a judgment, which was a remarkable. And people should be created that, no, they should, and we have to fix up a time limit. And it's not better, but some accountability is to be there, starting from the Supreme Court to down to the trial court, if there's an inordinate delay in pronouncement of the judgment. I think these are the two: quality writing in a precise, simple language, not running into hundreds of the pages. Absolutely. I don't know, Justice Karunakaran may highlight, is it necessary to write so many hundreds of the pages in a judgment? Can we express in a simple, short 2 pages? In fact, Professor Madhav Menon always used to tell us in the National Law School, write in a telegraphic language.
Okay.
Yes.
Well, let's
when a judge writes judgment, you must ask a judge whom you want to satisfy by writing this judgment. The litigants or the counsels involved, or you are thinking about the appeal and you are writing a judgment where there should not be any loopholes or create rooms for grounds of appeal. So judges should always look at that aspect. When you write a judgment,
there is some audio problem.
Should be
Honorable Sir, we could not hear you. It appears that there is some network issue.